This is a continuation of our video on the trial process. We ended up with the jury being selected, and now it's time for the actual trial to start. The first thing that happens is that the state will be given an opportunity to make an opening statement. That statement is not really an argument, but it's meant to tell the jurors a little bit about what the case is, what they expect the evidence to be, so that the jurors have an idea about what to expect as the trial goes forward. Your lawyer then has an opportunity to do the same thing, which is to present an opening statement. Sometimes defense lawyers do that. Sometimes they may decide to wait. You have the right to wait until the state closes their part of the case and make an opening at that time. And sometimes defense lawyers will wait because they're not sure what the state's going to present, and they want to have an opportunity to address what's been brought in and address what they're going to present and the evidence that they're going to bring forth. The state then starts. They'll bring in their witnesses, they'll ask questions. You have the right to, or your lawyer has the right to ask them questions, which is called cross-examination. The state then will have an opportunity to take them back and basically clear up any issue that they think may have been raised by your question. And then you'll have the opportunity to ask questions again, and that goes on until both sides are done or until the judge says enough. Once the state puts on all of its evidence, then their part of the case is closed. It's then your opportunity to put on your evidence. Sometimes a defense of a criminal case involves not putting on any evidence. Remember, it's the state's burden to prove guilt beyond a reasonable doubt. And it may be that based on the evidence that the state presents and based on the questions that your lawyer asks, they may decide, and you both may decide, that the state just didn't meet their burden and you don't need to put on evidence. But if you do, then this is your opportunity to put on the evidence that you want to put on. You bring in witnesses, and the trial goes essentially the same way. You put on your witnesses, you ask them questions, the state has the right to cross-examine them, and you have the right to clear things up. Once that's done, you put on your witnesses, the state then has an opportunity to come back and put on witnesses if they want to. And at some point the evidence is in and the case is closed. At that point the judge will then prepare what's called a court's charge. And that charge is a document that contains instructions which set forth what the law is. The important part of that charge is what the elements of the offense are, which is what the jury has to decide in order to return a verdict of guilty. They'll also have definitions in there if there are certain terms that have specific definitions, and other instructions about specific types of evidence that may have been admitted. This is the main function of the court, is to instruct the jury and to make sure they're given a charge so that they know what they're asked to decide. Once that's done, then the charge is read to the jury, and both lawyers have an opportunity to make arguments. Like the rest of the trial, the state goes first. You and your lawyer get to go second, and the state then has the right to close. Once the arguments are in, then the case is closed, the case goes back to the jury, and you wait for the verdict to come back, and hopefully they come back with a verdict that you like. There's some things that you need to be aware of about trials, and one of those things is that trials are public, and that means that anyone can attend. Everything in a case generally happens in open court. There are exceptions, and the exceptions generally happen while the case is going on. There may be certain things that the lawyers want to address with the judge, or the judge may want to address with the lawyers, and they don't want the jury to hear it. A lot of times when you have objections to a certain piece of evidence, you don't want the jury to know what your argument is, and you don't want the jury to hear the discussion that you have about why you think the evidence is admissible or not admissible. And so the judge will either call the parties up to the bench and have a conversation with them there, or they may go back into the judge's office and have the arguments there so he can make a decision about whether the evidence is going to come in or what's going to happen. It's also important to remember what the function of the people there are. I already mentioned that one of the functions of the judge is to instruct the jury and make sure they have the law that they need to make a decision. The judge in any case is like a referee. He or she is not the person that's making the decision. The jury is the one that's making the decision. The judge is the one that's there to preside over the trial when objections are made. They're the ones that have to rule on those objections. They're the ones that keep the trial moving and make sure it's handled the way that the law requires. As I've already said, the jury is the one that makes the decision. Whether or not you're guilty or not, in a jury trial, that decision is for the jury, and the judge has no part in that. That is why they are the most important people in the courtroom. I hope this has been informative and at least given you some idea about how a trial works. It's not meant to provide you or talk about strategy, but simply to let you know the process by which a criminal case is generally tried. As always, if you have any questions about anything about this, or if you have any questions about anything specific to your case, please give us a call.